Okay, so I suppose now everyone can hear me. Yes. Okay, so let us start with the today's lecture. Everyone can hear me, right? Okay, good. Let us start with the today's lecture. See, today I will be talking basically two topics, okay? And both of them are very important topics actually. Yes, good afternoon everyone. Very good afternoon. See, today I will be talking about two topics. Let me show you the slide. Yes, these are the two topics that I will be talking about today. That is the union executive, that is the constitutional position of the president and with relation with the council of minister. That is the first topic that I will be talking about. And then the second topic, that is the governor and his powers, right? That is basically the state executive. Okay, so that is the two topic that I will be covering today. Okay, now let us delve into detail that what are the things in these topic that you need to study for UPSC optional. Okay, see, if you look at these two topics, I have bifurcated the subtopics that need to be studied in these two topics. Okay, now I think I should wait for 1 or 2 minutes more, right? Because a lot of people are still joining in. Yes, let us wait for 2-3 more minutes right now. One more thing I wanted to ask. This coronavirus lockdown, obviously the prelims have been postponed, right? So obviously it will go for, I think, a very longer period, right? Even after up to July and August, people are saying that will go, right? So obviously it is a very good opportunity for you law people, right? Colleges will also open after, I think, September, August, September. So if you are already in college, you have almost 3-4 solid month that practically you can sit and prepare the whole law optional. Okay, so that is a very good opportunity for you all. Okay, so if you can do that. Yes, GS2 I will take 9 p.m. today, right? Today at 9 p.m. I think that de facto IS telegram group, right? I will send the link in law optional group also. If you want, you can attend that class as well. Okay. Yes, questions I will take later on. Okay, Abhishek, I will take questions later on. Let me first finish with the today's lecture. Okay, then I will take questions. Okay. Now today I have also changed something, that I will show at least 3 copies and I will send all the 3 copies that the people have written. Okay, right? And also I will explain little bit more, right, what you have to write in that particular answer. Okay, because I don't used to do that and the people have said me, sir, I don't know actually what to write in that answer. Okay, so I will little bit focus on that as well today. Okay. My class at New Stencil will start, I think, in around 12 or 13 or 15, something like that. I will email you the one good email, right, in which I will describe all the courses that I will be taking at New Stencil online. They have put it up the camera, right? Yesterday they came and the people have put up the camera. So I will email you, okay, that I will talk later. Okay, not to it. GS2 will be at 9 p.m. today. Okay, today at 9 p.m. Good. I will send that in the group itself. Okay, Abhishek, not to worry. And if you have filled that form, I will send that form as well. Okay, so in that form also you can understand that. Okay, now let us start. I think most of them 80-90 students have arrived. Okay, see, today we will be talking about topic 4 and topic 5 of the law optional syllabus. Okay, now topic 4, if you remember, and topic 5, that is in the serial number. Okay, so serial number topic 4 is basically your this whole union executive. Okay, and topic 5 is basically governor, that is the state executive. Now if you look at these two, right, these two topics actually is a very interesting topic, in the term that the questions are mostly comparing with these two topics. Okay, it means ki they almost they are similar in nature. I will not say exact same, but at least they are similar in nature. Okay, then the question arises that what are the subtopic that you need to study in that particular topic. Okay, so let me explain you that. See, if you look at the syllabus, right, these two syllabus, then I have divided it into 1, 2, 3, 4, 5, 6, 7, 8, 9 subtopics, right? Yeah, the 9 sections in these two topics that you have to study, you have to focus on. Okay, so let me go one by one in each and every section. First is the usual constitutional provision with focus on executive and legislative power, right? So most of the question in executive power. Okay, now not only the executive power, but also the nature of executive power, the source of executive power, right? If you remember, in the case of governor or in the case of president, the source of executive power are multiple articles, right? Like article 53 talks about the executive power will lie with the president. Similarly, article 73 talks about it. 74 also mentioned it, right? So if executive power is conferred upon the president, then why this multiple articles? Does their scope changes or its scope remains same? right? It means the executive power conferred upon the president by the verge of one article and the verge of another article. Does the nature of those article changes? Okay, so that particular part actually you have to focus more. Okay, so when I talk about constitutional provision, then I talk about the nature of constitutional provision as well. Okay, so you have to understand that particular point in quite detail, right? What is the nature of that particular executive power? Not only the executive power, but the nature of source of executive power, right? And the source lies in different articles of the constitution. Okay, so that thing that you have to write, right? You have to pinpoint it, and you have to see the whole spread, right? It means there are other articles also which gives, like there is a Henry VIII clause in the constitution that says ki president have power to remove any difficulties. Okay, now that is also a source of executive power, right? So how that executive power is different from the executive power conferred by other articles. Okay, so that particular point you have to pinpoint. Okay, so the executive power and legislative power, source and pinpoint the articles. You should by heart know the provisions of article that you have to quote. Okay, this article says this article says this. Okay, and that actually you can sort of compare and study. Okay, so that is very much is required. Okay, second thing is the judicial power. Right, now judicial power, in the last 10 years I could find only one question with respect to judicial power, right? But I will not say leave it, because it is a very simple concept. Now in the case of judicial power, mainly the criticism comes, okay, that how the judicial power is somehow taking the turf of judiciary. Okay, so that particular criticism you should keep in mind, right? I have given a case law also, right? A very famous state of Kerala case. I will discuss it. Then the third key thing that you have to understand in these two topics is basically key concept, certain concepts such as collective responsibility. What do you mean by collective responsibility? Now there are various dimensions of the collective responsibility concept, right? Like for an example, the dimension that says that okay, if a minister says something, it will be the council of ministers which is responsible. Now in the case of advising, does it mean that whole minister should advise, or the prime minister should be the connective link between that particular collective responsibility? Okay, so more deeper meaning of collective responsibility has to be understood, right? More in the sense of the parliamentary provision or the parliamentary democracy like ours. Okay, because the concept of collective collective responsibility do not exist in the presidential type of government. It only exists in the parliamentary type of government. Understood? Second is the dismissal of a minister, right, where the prime minister can dismiss a particular minister, right? And if a dismissal is given, advice is given, does it binding on the president? Okay, that is the next topic. In fact, the discretion of the president, that is another subtopic or the concept that you have to understand. Now in the case of discretion, a very interesting concept comes of the constitutional conventions. See, while framing the constitution, we have adopted the British model. Now in that British model, there are certain things called constitutional conventions, meaning they are not written law, but they have been followed and court uses that in the judgment as well. Okay, so in India, what are the constitutional conventions that have come into picture? What is the legal value of constitutional conventions? What will happen if that constitutional convention is not fulfilled? Right, now one thing more you can understand, that whether this particular constitutional conventions will work in a good way or not, that is also required. Okay, see what happens that when we have a gap in the existing provision of the constitution, then constitutional convention sort of introduces flexibility in that particular gap, right? So that is a very interesting concept regarding constitutional conventions. You have to delve in deeper and you have to understand the constitutional conventions with regard to India's requirement, right? What have evolved, right? What have been judicially recognized, and what has been evolved only politically recognized, judicially has not been recognized. Okay, so those sort of things. In the in the case of discretion, right, that I have written, I think somewhere here also, constitutional convention. See here, constitutional convention, their legal status under our constitution, right? So there have been questions on that, right? So focus there. Then judicial scrutiny of the council of minister. Now you must have seen the article that provides 74, right, clause 3 or 4, that provides that okay, the court shall not inquire into the the advice given by council of minister to the president. Okay, so can the court go into judicial scrutiny? Very famous case where the advice have been conferred in the case of implementation of president rule, and the court said that no, this particular article only protects the advice given by council of minister, not the material on which the advice was generated. Right, basically I can ask for file on which the advice was generated, so it is one and the same thing, right? But still the court have differed and have asked differently. Similarly, how such executive power affects the constitutional governance of the country. Okay, so that is sort of a criticism of the constitutional governance of the country in terms of non-precise definition of executive power in our constitution. right? So philosophical aspect of the executive power, nature of executive power, right? So that part also you have to focus, right? So keep that particular thing in mind, right? Because constitutional governance is a topic that is there in the case of, this in the case of administrative law as well, right? So there have been questions linking the executive and the nature of executive power and constitutional governance. Okay, so you have to read more in detail that how this nature of executive power, how this executive power that is spread throughout the constitution, that varies the constitutional governance, yeah, that affects the constitutional governance of our country. Okay, so that part actually you have to focus. I will show you the questions, previous year question, you will understand. Then the unique position of president, right? Why unique position of president is there? Because president, have some of the characteristics of the sovereign, that is the British, right? And the president have some of the characteristics of, a democratic like India. So that is the unique position. It is neither this, neither that. Okay, like in the case of Justice Ayyar, very famously he said that the position of the president, or the president, not president, president of regarding the position of president must be enriched by river Thames rather than the river Mississippi, that is US. Okay, so it has to be London, right? That is the unique position of the president. I have given a case law also, that if you will study very uniquely, it have talks about it. Then the constitutional position, unique position with regard to governor, and how the governor is betraying the constitutional trust placed in them, right? So you have to compare the provisions. Almost everything is similar, but there are slight difference, right? Because the governor have more discretionary power with respect to the formation of government and other than the president. Okay, so that particular constitutional trust, how to maintain that constitutional trust, right? So you have to pick up good lines and you have to write that in exam. Okay, so that is the contrast that you have to study, right? So these are the subtopics you have to go through. You have to find material regarding that, and you have to read. You can use V.N. Shukla or whatever book you have, right? But read only those points. Okay. Then focus on the bare provisions. Sometimes there is a direct question. Article 74 discuss the scope, right? So those direct questions has to be studied with simple case laws and the keywords. Now what are the keywords that you will focus? Like what is the meaning of advice? What is the meaning of personal satisfaction, right? So mere a direction or mere a writing letter will amount to advice by the Council of Ministers to President, or the direction given by President to the Council of Ministers, is it binding or not, right? So that is what I am talking about, the keywords. Understood? So those keywords has to be studied along with the case laws. Okay, so bare provision, in fact bare provision in any act, right, of the parliament is actually good to study. Okay, so bare provision obviously need to be studied. Then contrast between the power of president and governor, right? I have told you mostly they are similar, but they differ in certain aspect, right? Like I have again told you that the discretionary power of governor is much more than that of the president, right? So there have been question pinpointing that, okay, what is the more discretionary power that the governor have which the president don't have, right? So that pinpoint provision has to be there. Okay, that you should really study a lot. Then qualification, disqualification, PM or CM, right? There was a very famous case when the person was convicted and he was disqualified, but still he was elected. She was elected in the case of Jayalalitha actually. Still she was elected as a head of the house or the CM, right? Now the question is that whether she can be appointed as a chief minister or not. Okay, so there was an argument that okay, the disqualification all kicks in after 6 months. So at least for 6 months she can be CM, right? The court held that no, once you are disqualified and you are not elected, then you are also disqualified for being the member of, being the chief minister, even for that 6 months. Okay, so that is something very unique position that the court have held, right? Similarly, if you will read the article related to Council of Minister, the 2 times there is the word minister have been used, right? So in the one clause the word minister do not include prime minister, in the other clause the word minister do include prime minister. Understood? So that is something you should try to understand and study. Okay, right? Now let us come to now you will see that there is a very huge spread of the whole 2 topic, right? So you have to read a lot in these 2 topics, right? So please keep that in mind. Obviously I will send you this PDF, but please keep in mind and study each and everything that is given there. Okay, so please do that. Now let us come to the case law. The most important case actually, Madhav Rao Scindia versus Union of India. See, that is what the comparison between these 2. Okay, that is there, right? See, first is there is no analogy between our president and the British crown. The president is a creature of constitution, right? It is a creature of constitution, right? So president cannot say that I derive my power or it is similar to the British crown. It is the creature of constitution, so it must be controlled by the constitution, right? See, he can act only in accordance with the constitution. Okay, so even if president have some attribute of sovereignty, he shares some attribute of sovereignty, still he is not a sovereign entity, right? So he cannot compare themselves with the queen. Okay, similarly, it was said there that Article 74 of the Constitution as it stands now after 42nd Amendment, the President is bound in every case, be it so-called constitutional, executive or legislative function, to act on the advice of the Cabinet. Okay, it means now it is a settled law that you have to follow the advice. If you do not follow the advice, you are violating the Constitution. Understood, right? So that is the most important case. It was a 11 judge bench. Okay, so it is a very authoritative judgment. Okay, now I will suggest you to read that judgment in whole. Okay, why? Because you will find good lines to write that in exam. Okay, so please read that judgment in whole. Very, very important judgment. Okay, similarly, similarly the president cannot go directly, indirectly what legislature cannot do directly. Okay, so you cannot make law, right? It is wrong to mistake duty for a right. Okay, so when the president acts certain thing on the advice of Council of Ministers, it is the right, not the right of the president, but the duty of the president. It means he must act. Okay, so this is how beautiful line it is. It can be directly quoted in your answer. Okay, that will make answer very good. Similarly, second question, again this is a very important not question, sorry, this is a very important judgment of 5 judge bench, constitutional bench judgment, right? It actually talks about that what is the discretion that the president have. Okay, now the question was that whether the president can, while dismissing the minister, can ignore the advice of the prime minister. Obviously the answer is no. See here, it have been further held that even if the House of People stand dissolved, such dissolution of House does not require the Prime Minister and other minister must resign or the cease to hold office or must be dismissed by the President. Okay, so what is the option that the President have in that case? When the House is dissolved, right, then the President have only one option, that whether you have commanded the majority of the previous House or not, you reappoint or you reappoint another person as a Prime Minister. Okay, and ask him or her to prove his or her majority. You cannot by right say that okay, House is dissolved, Prime Minister is gone. No, not at all. Now there is again a constitutional convention that when a House is dissolved, the Prime Minister basically is asked by the President that you please continue till the new President comes, new Prime Minister comes and takes office, because there is no constitutional provision that talks about that what will happen if there is no Prime Minister. In the case of no president, there is a specific provision that okay, vice president will take over. But in the case of prime minister, there is no such provision, right? So that is the hollow part, you can say, that is the left apart part of the constitution that has been filled by the constitutional conventions. And one of the constitutional conventions have been laid down in UN Rao case. Okay, so that is a very, very important thing that you should keep in mind, right? So one case I gave you regarding this constitutional conventions. Similarly, the 9 judge bench in it is basically Advocate on Record Association, Advocate on Record Association versus Union of India. It was held that the president has no discretionary power as in the case of governor, even though the discretionary power of governor is only a small strip. The president is required to perform his administrative duty under the constitution, the performance of which requires his formal approval. Simply a formal approval, right? They cannot actually say and come up with his or her own policy that okay, this should be done. They cannot do that. Understood? Okay, so that is something very interesting case. Again, it was a 9 judge bench case. Okay, so it is a very important ratio it is. Now let us come to the another case, R.K. Jain versus Union of India. Now the cases that I am referring, these are the only landmark cases that need to be studied, right? In multiple book you might find multiple landmark cases. Do no need to refer that. Only refer these landmark cases. Okay, I have pinpointed certain paragraph, but I will suggest you read the important paragraph, each and every important paragraph, right? That will actually help you. Okay. Now, the above discussion leads to the following conclusion. There was a lot of discussion, argument from both sides. What? The President, while exercising the executive power under 73 and Article 53, discharges such of those powers which are exclusively conferred by his individual discretion, like this, under Article this, not open for judicial review. Okay. So this is basically the difference I was talking about. The President have been conferred power under Article 53 and Article 73. So what is the difference between that two? Understood? Okay, so that is the constitutional, that is the case law that actually differentiates between that power. See, the President exercises his power with the aid of the advice of the Council of Ministers, with the Prime Minister. They exercise the power not at his delegate but as officers subordinate to him. Okay, so when we talk about constitutional power, I mean executive power, article 53, it is basically officers delegated to him, right, below him, right, IS officers, secretaries, etc. But when we talk about 74 executive power, so that executive power has to be exercised on the advice of Council of Ministers, right? Now that advice basically overtakes the advice of 53, right? So the executive power of 53 is limited in nature, right? And the executive power in 73 is much more wider. Okay, so that is the very small difference, right? But a very important difference, I must add. Okay, so you please read that RK Jain case, it clears everything in that. Okay, now let us come to the pardoning power, or you can say this judicial power. Same thing happened in the state of Haryana versus Jagdish. See, here the court have always also commented on the nature of the judicial power as well, right? That is actually asked in our UPSC exam. Okay, the power under 73 and 164 was never intended to be used or utilized by executive as an unbridled power. Okay, it means it must be limited by the constitution. Okay, it cannot be acting as a replacement of the judicial power that the judiciary have. Okay, so the purpose was that the judiciary is involved in procedural laws and everything, right, and that leads to sometime injustice. So executive can see with plain eye, they can talk about surrounding circumstances, and then they can have a much better look at particular thing, right? So that is the last step it have been given, right? So even if the clemency is granted, that clemency is again subject to judicial review. Okay, that is what the court is saying. Power of clemency is to be exercised cautiously in appropriate cases, which in effect mitigates the sentence of punishment awarded, which does not in any way wipe out the conviction. Okay, so what the executive can tamper with the sentence only, not the conviction. That is the part of the court. Okay, so that is the exact ratio that you must understand about the judicial power. Okay, similarly, it is not a sovereign function. See, the power of sovereign is to grant remission is within its exclusive domain, and this responsibility was cast upon executive through the constitutional mandate, right? So even if it is a function of sovereign, then you cannot say that okay, president have been given this similar to a sovereign function, then president is sovereign. No, it simply means that okay, it is a sovereign function to grant any pardon, because you can pardon any of your subject if you are king, but that sovereign functions entrusted with the president doesn't mean at all that the president is sovereign or the president is performing a sovereign function. He is performing a function which is generally reserved for sovereign, that is okay, but he is not performing a sovereign function. Okay, because the president is not sovereign at all. That is the basic premise we should understand here. Okay, so again a good line, I have given 2 good lines. Okay, now let us come to the previous year paper, that what are the things that need to be studied in, what are the questions that came. See, this whole question is almost a paragraph, right? Let us see the question. It says discuss the constitutional position of the president. Yes, we have discussed, right? On the eve of general election of the Lok Sabha, it was asked in 2016 after this election, right? Just after the last session of parliament, the government sends an ordinance to the president, right? It means it was a lame duck session. Now the new election will be called, right? And the ordinance was sent to the president, extending the benefit of job reservation to Dalit Christians. Manmohan Singh government did the same thing. He sent that ordinance related to reservation in Haryana, right? That I think we discussed in the last classes. The president returns the ordinance and asks the cabinet to reconsider its advice. Is the action of president sustainable on the under the constitution? Obviously the answer is yes. One time he can return any advice, right? But if second time he returns, then the constitutionality comes into picture. Okay, so it's a very plain and simple question, right? What you have to do, you have to discuss a little bit about the president, right? Constitutional provision, you can write that how there are certain gaps which have been filled by the constitutional conventions, right? And then you can talk about clauses 74, 75, right? Some clauses which provides for this, and they say that okay, the act of sending once back is provided under the constitution after 42nd amendment, so there is nothing unconstitutional about it. Okay, now one more aspect of it is that if that house is not going to end, right? So if that house is going to end, that doesn't mean that the prime minister will also end. Okay, it means that as soon as the house stands, even after the house ceases to exist in terms of this, this proceeding, right? The last proceeding was there, but the house has, I think, in this question not dissolved. Okay, it was on the eve of general election, right? Just before general election. It means the house still persists. If the house would have been dissolved, then the separate matter would have arisen in this question. But house is still existing. It means it have been prorogated, but it is still existing. It means the prime minister's advice will be binding. only case where the Prime Minister advice is not binding if the House is dissolved and he is a caretaker Prime Minister. That is again a constitutional convenience. Okay. Similarly, let us come to question number 2. Discuss the ordinance making power of the President. Very simple, straightforward question. Can the validity of an ordinance be challenged? Yes, very famous case law. You know that state of Bihar versus this. There are 7 grounds on which it can be challenged. Right? Simply read that particular case law. Then, with the adoption of parliamentary form of government, the vesting clause under Article 15, Clause 1, there shall be a president and he shall, yes, remains to a great extent meaningless as the real executive power lies with the ministry, that is with the government, right? Now again, what is this? This is basically talking about the criticism of the arrangement that we have, constitutional arrangement we have. Okay, it means the unique position of president is there, even though he is the de facto head, he is not the, sorry, de jure head, he is not the de facto head. Okay, that is actually the question he is asking, demanding. So you have to cite all the case laws that I have given above, okay, at least the first 2 case laws. Critically examining the above statement in the context of status and the position of the president, okay, under the Indian, also answer if the President of India does not accept the advice of Prime Minister, what consequences would follow. Okay, so constitutional conventions, if some have been recognized, you can go for mandamus, writ. The government can go writ against this, or any private person can go against the writ against the president, or second thing, the parliament can impeach it because it will amount to the violation of the constitution, right? That is the only thing that is there. Okay. What is the position of governor? Again, straightforward question. Examining the pardoning power of the governor, the same case that R.K. Jain versus State of Haryana. It was R.K. Jain, I suppose, right? No, Jagdish versus State of Haryana. Okay, so that question. Is pardoning power subject to judicial review? Obviously the answer is yes, right? You should write that the purpose of pardoning power is different. It cannot be used as a clemency. Do not, expunge your conviction. It can only modify the sentence. Okay, all those things that have been written in that judgment. Okay, that is the answer, right? So in the last, 5 to 10 years, I could see, 5 years actually, not 10 years. In 5 years, I could see only these 4 questions out of them. Each year there is 1 question around. Okay, I think 4 more questions were there, but they were similar in nature, so I have clubbed it down to 4 itself. Okay, yes. So that is the today's class. Now let me dictate you question today of today's class, right? And that question I have said that this will be question number 2 itself, right? This will be question number 2 itself, right? So you have to write this question number 2. Okay, so try to write this question number 2 and send me the PDF. Okay. Now, before asking any questions, I can come up with, yes, this Ipru Sudhakar case is also correct, but see, there are a lot of case law, right? So only write the major ones. Okay, Ipru Sudhakar you can mention obviously, right? But in each topic, pick up, okay, these are the 7 cases that I am going to cite, that's it. Or these are the 5 cases. Because if you have a lot of these, these cases that actually do not make sense, okay, it clubs actually, it creates a problem in sense of your this, okay. So that is one thing you should keep in mind. Okay, now let me check some of the answers, right? Then I will take everyone's question, okay. See, I keep telling you the email ID is defactolaw.in@gmail.com, okay, you email there. Good, let me see the answers today. See, one answer I have taken, 3 answers actually today I have taken, 4 answers in fact, but I will check 3 answers. PIL has brought people and code together, right? Now what was the expectation from that question? The expectation was, it was a philosophical question, right? So you have to write the philosophical aspect along with the case laws or along with its relationship with certain part of the certain part of the constitution like DPSP and fundament, right? So that was the expectation. So let us see, or how this actually evolved, what is the purpose. Indian judicial system witnesses sprouts of public interest litigation, which was, yes, good introduction. Yeah, philosophical, good, 2-3 lines, that is a very good introduction. Then you have come through PIL, good. When PIL can be filed. No, this is not a question answer session, right? So not like this, right? PIL, no, this is not required, right? You can write here position, or you can say, constitutional provision, right? That thing you can write. Remedy, emission, putting on other one, when go interest or good. Human rights, okay. So you have talked about PIL, good. Compel municipal authority. No, these are, going into too much detail. Simply write, in very short, okay, these are the use of particular PIL, okay. Bring courts, yes. You have not mentioned environmental cases, right? Whether your aspect, you might have mentioned, later on, let me see. Knowing courts and the public together, bringing court in public together. USA, yes. PM Bhagwati, good. good. Very good. Uses you can write here. Uses here some of the examples of the use of PIL, right, that you can mention there. Song with the brutalities of place. Brutality of place, it is not Anil Yadav. I think the WB Basu, I think the name of the case. West of Bengal versus D Basu, I suppose. I might be wrong, you check it once. I went to PIL people through W. Yes, good. So, but again, you have, missed that environmental jurisprudence that I talked about, right? You can talk about recent cases. You can talk about sometime it is, also used as a negative consequences of PIL, right? So every aspect has to be mentioned. Okay. So in spite of getting benefit, it is becoming a publicity interest litigations in some cases. Just a passing reference in the middle somewhere you could have mentioned. Okay. So whoever copy it is VRM, I don't know the name, right? Now let us come to the copy number 2. PIL has brought, okay, file protection of the public interest, okay. See, he have tried to club everything in the introduction itself, right? So you should write 3-4 good philosophical lines, then you should, move these in the, in the this part. And the concept has, PIL has mostly, since it was filed in Hussain, okay, good. Now see, what is wrong with this answer? Anyone can point out presentation. Very tough to read. You could have written much bigger, right? The structuring is okay. See, it seems to be repetitive. The same thing that you have written in beginning. Ombudsman, as a forum, as a mediator. No. PIL mediation doesn't happen. It is plainly wrong actually. In PIL, it is in absolutory jurisdiction. Basically, they make you to approach court friendly. Okay, but they do not mediate. Never. The function of court is to never to mediate. There is a separate provision in CPC for mediation, 89 or I think 85. PIL public welfare. Good. This is a good headline. Now, instead of writing this 1 second, right, you could have first written a normal paragraph, then in this case, right? That would have been a better structure. Yes, that is good. Very good actually. Very good. Weaker section. Very good. Okay. But Supreme Court has not responded in this COVID. You must have seen. Right? Supreme Court is simply saying that whatever the Tushar Mehta is saying, our Solicitor General, that is very correct. In fact, I think when this PIL was filed, then only a 5-page affidavit was filed from the government of India saying that I am doing everything, and court accepted. Yes, see, they are saying that they are doing everything. Why to worry? Everything is, Ram Rajya. No need to do anything. And the court can find time to issue, that against that editor. What is the name? That loud mouth editor. Republic TV 1, right? So they are actually, giving them relief, right? Arnav, yes, giving them relief to Arnav that okay, after 3 weeks no coercive action can be taken. So the court have time for that, right? But the court do not have, and that too the FI was filed in the bailable sections, right? It was not punishable offences, right? But still the court gave him reprieve. Okay, that is something, very biased approach actually, but still that is how the things function. Security, human rights and human dignity, good. Success story, okay. Good, but here some criticism could have been added again, right? Criticism, some part of criticism, not 2-3 lines, right? Mention 2-3 lines. Okay, then there again, that is good answer. Now, let me see. This copy I was looking at, this I don't know who he or she is. He or she have written good answer, but the structure is so poor, right? She have tried to, I think, or she, I think, this is some girl, right? She have tried to fulfill each and everything. So you have tried to write each and everything with different points in shorter versions, so that sort of coherency of the answer have been lost, right? So the coherency of answer is also important actually, right? So you should try to be coherent actually. Okay, how they can challenge when they praised our PM as superhuman in world judiciary. Talking about Justice Misra's comment, right? Justice Misra is very sometime he have past remark, right? He is not a bad person per se. Justice Arun Misra is a short-tempered actually. Okay, so PIL is power. Okay, good. Now one line only, right? Right, at least two lines, right? Introduction. Black law dictionary. Yes. See here, this presentation is bad. Right. You should not write something like black law dictionary. Then you write this. Or black law dictionary defines PIL as, right. Why this space is empty? A small thing. See, presentation is making your answer look beautiful as well. Okay, that is also important. No marks I am not providing anyone, right? Because you might get disheartened by the marks, right? You write it down, practice it till we reach the end of the course. You will understand. I will start giving you marks. Okay, so marks, discourage people. Okay, so let me just comment and try to understand that. Earlier, the enforcement has to move directly, high cost. Okay. See, so you have written a very good line here, good paragraph. Pioneer. No, don't write pioneers here, right? You can write development. Then you write the pioneer have been there. See how bad presentation is there. No, this paraphrasing is not proper, right? So obviously, while looking at this answer, you have good content, but paraphrasing. That is what I keep referring. Three things: structure, presentation, and content. You have very good content, right? But see, the presentation is not. You have given the structuring is also better. You have given heading and subheading, but small things in terms of presentation is not there. Okay, so that thing you should keep in mind. First PIL, why to write the, or you can write one line, passing line, not the whole paragraph. Yes, case law, very good, important case. Here I got people. You could have given heading there, such as. No, you are writing as if you are taking lecture, right? So don't write like that. See, the best way of writing these type of answers, right, is that suppose you write the court have granted relief to landed laborers, write the case law in between, and to these people, write the case law in bracket, right? So that gives you a very good two things, right? It can convey the person checking that you know the case as well, and it will shorten your answer as well. Okay, so lot of content you can concise in few lines. Okay, so that is the best approach of that. Now, do not write generic heading, introduction, body, conclusion. No, not at all. Do not write generic heading at all. Okay? Good. Yes. So you have written again the presentation part, whoever copy it is, right? Presentation part you improve. Now the last copy I am taking, the fourth one, because that copy I find it is a good copy actually. Have brought people, okay? The traditional rule of litigation, very good. Very good. The concept of PIL arises out of processing. Good. So you could have given here headings, okay? That would have made things better. Class of person who good. Right, very good line you have written. I have read this answer before as well. It's a good answer. The concept further see, you have written a very good keyword, making it accessible, applicatory jurisdiction, even foregoing all the procedure and taking letter even as a very good. See, this is the way of referring cases. ठीक है? Very good. Who is Ramya? I think she is again in one of my writing practice batch, I suppose. Ramya is here. Please reply if you are here. Ramya, yes, I can see Ramya is here. Yes. You are in my batch, one of batches, Ramya? Yes, you are. Good. You are improving. You have written, see how philosophical lines very nicely you have written. Now again, Ramya, you have forgotten to structure it better, right? So there has to be after long paragraph. Do not write long paragraph. Write headings and subheadings. Okay. So structuring part has to improve, Ramya. Otherwise, your content is really very good. Necessary idea of see. You have also written this part as well. Okay, that is a perfect answer actually. Okay, very good actually. Right, all part you can practically compare this answer with your other answer, and you can find this answer to be much better. Yes, so there has to be heading and subheading. That is, see, always remember there has to be structure, there has to be presentation, and then there has to be content. So content part is basically collecting knowledge, the structure part is collating that knowledge, and presentation part is writing it. Okay, so three things has to be mentioned and always has to be remembered. That is very, very important actually. Today's question I have already told you here itself, right? Question number 2 is the today's question. Okay, so this is the today's question that you have to. Yes. Now I will take question one by one. Please raise your hand if you have any questions, and then we can. Yes, Mr. Nahar, please go ahead.
Good afternoon, sir.
No, good afternoon.
But like you just raised the issue of Supreme Court not allotting adequate time for the COVID TIL,
Okay.
but deciding to hear Arnab's case in an urgent matter. So what type of question can we expect on this regarding?
No, you cannot actually expect any question that I mentioned. Just someone asked me a question. That's why it was sort of a criticism.
Can this be a drawback towards the judiciary if we write an answer on it?
See,
working?
in larger perspective, what you can see that the process of allotting cases to the benches is actually problematic. Right now, what happens? It is totally with the discretion of the Chief Justice of the Supreme Court that they can allot bench. They have a roster system, right? And they can allot whatever they want. Okay, so that is actually problematic, right? So it is a larger perspective, right? So Arnab Goswami, that obviously that will not come in question. Okay.
This was just in reference.
Yes, just a passing reference. Okay. Mr. Realme, you change your name, then I will unmute you. Yes, Ishan, go ahead.
So my question is related to the duration of this course, actually to the content of this course. Could you completing? I'm sorry, like.
No, I have told you that I will take. See. Let me answer your question. I will complete these two, three topics. I will take daily and will explain similar way, in similar fashion. And I think we have 70 topics, so I will finish that in around 30-35 days. Okay? But it is not a substitute of main class, obviously. I have already said. I could not.
Okay, I should join the main.
Yeah, obviously. If you wish to continue. Thank you. Navneet, yes, please go ahead.
Good afternoon, sir. Am I audible, sir?
Yes, you are audible. Go ahead.
Sir, you told us about there was a question in one of the subtopics how executive power affects the constitutional governance.
Yes.
So इसमें सर अगर हम particularly बोले तो हमें कौन से articles को refer करना होगा और क्या दिखाना होगा question में क्या affect क्या कर रहा है
उसमें ये दिखाना होगा कि the constitutional provision you can refer article related to executive, sometime parliament as well, and say that there is no clear separation of power, and that affects the governance part, because while time of taking action, the person cannot verify that which particular part is what. I mean, which authorities have to do what function, right? So there is a blurring of the separation of power.
Okay, sir. Also, one more thing. Yes. This answer you just showed us, Ramya, I know. So, yes, she has written a good answer. I have also written an answer, but इसके आसपास भी नहीं है. So, can you also send this copy in the group itself?
Obviously, I will send it. You need not to tell me again, right? I will send it. Okay, I will send it.
Thank you so much, sir. Thank you.
Ishan, I have finished. Yes. Dinesh, yes, go ahead. Dinesh, please go ahead.
Good afternoon.
Good afternoon.
So my issue is about election of president.
Yes.
Normally in our country, only the elected people of both the houses in each and every state and the parliament will elect.
Yes.
Actually, the UTs only Delhi and Puducherry will elect. They participate in the election, not other UTs actually. What about the new formed UTs of Jammu? They will participate in the election, or in what kind of the strategy these UTs selected for the election?
See, obviously, if it have become a state, then all the state provision will apply to those states, right? So there will be nothing new cannot be done, right? In the case of these, the newly created UT, the UT provision will apply. If the union thinks that certain new things has to be added, there has to be a chief minister, then a special constitutional provision has to be introduced, right? Like in the case of Delhi, it is 239AA, okay? So if something new has to be done with the case of Jammu and Kashmir, newly created union territory, then a special provision has to be introduced. Okay, so I will take 2-3 more questions. Okay, I have only 10 minutes left. Okay, let me unmute Miss Suha Sahul. Yes, please go ahead.
Yes, sir. Good afternoon, sir.
Yes, good afternoon.
Sir, while writing answers, I sometimes tend to forget the names of case laws. So in that case, can I write in the leading case and write the facts then?
Yes, you can write, but the leading cases you must remember. That is why I told you in the beginning that in each topic.
Yes, sir, like I sometimes confuse myself with two names.
I also I also sometimes do not remember. You must have seen I sometimes forget the name of the case. I remember the ratio, but it is a habit that you have to develop, because if I forget, there is no problem. I can always say that, okay, look in the notes, you will find it, right? But you have to write that in exam, right? So you should not forget it. Right, so what you do actually, that you make a list, paper list, or this in fact get a printout of this PDF, right, and write all the extra cases that is needed there, and keep on revising that, right? So that is a very good method actually to write that down.
Yes, sir. Yes, sir. Thank
Okay,
you so much.
thank you. Yes, Realme, go ahead.
Thank you, sir. Good afternoon, sir.
Good afternoon. Please go ahead.
Sir, I want to ask that what is the difference between pardoning power of president and governor, and why the president of India is having pardoning power?
Why it have, that I have already explained, that judiciary sometime while applying procedural law will not be able to do justice, right? So the executive can see the ground situation and in certain exceptional circumstances can pardon, right? The difference constitutionally speaking between this governor and this is that, let me briefly tell you. See, there are basically sentences. When court pronounce a sentence, there are two type of sentence they pronounce, right? You might be punished under a union law, you might be punished under a state law. Okay, now the president can pardon you all the cases in which you have been, all the conviction that you have been convicted under the union law, and in the case of any death sentence, and that sentence can be under state law as well as union law. But the governor can pardon you only with regard to sentence that you have got under union law, state law only, right? So if you have been punished under state law, then only the governor can pardon, right? For an example, let me give you a further example, that suppose a person A, he was punished for 5 years under union law. He was punished for 7 years, he violated the second law under state law. He was punished for death under state law. He was punished for death under union law, right? So that was the judgment. Okay, in the judgment they say, okay, you have violated this law, this is the punishment. Okay, now in the case of this particular conviction, the president can pardon first, president can pardon this too, death, but the governor can pardon this 7 year because it was state law, and the governor can pardon death with relation to only state. Okay.
So by saying union law, state law, what does it mean?
By law passed by parliament, law passed by state legislature.
Sir, simply IPC is passed by both the houses.
No, it is passed by the parliament. Are you law student or not?
Yes, law student.
So you are law student. The reason I asked, because this is a very simple thing actually, that when a law have been passed by parliament, we say it union law. When it have been passed by state legislature, then state law. Now the procedure of passing and everything, obviously that is different. Okay? Okay. You are very weak, Realme, you have to improve. Devika, yes, this is the last question I am taking. After that I will not take any question. Yes, Devika, go ahead.
Hello, good afternoon, sir.
Yes.
Yes, sir. So my question is that in this PIL question, so you were referring that we have to write with connection to fundamental rights and DPSPs.
Passing mentions, yes, that Article 32 lead to this, right? And yes. PIL is basically a court way of implementing DPSP, right, in a passing mention manner.
So do we have to write about all that also, that it was given in DPSPs that we have to secure social and economic justice?
No, just as a passing line in 2-3 lines. 2-3 lines that I think Ramya have properly given. Just a passing line, that's it.
Oh, okay. And sir, about the criticism, should we mention it in the end as a conclusion that...
No, not in conclusion, just before the conclusion. Conclusion, you support the idea of the question itself.
Okay.
Okay?
Sir.
Good.
Thank you, sir.
Thank you. Okay, so that is all for today. And Hardik, yes, मैं हिंदी में भी बोलता हूँ बीच में, right? But there are a lot of people for southern country, southern part of our country, right? So sometime no problem, आपको दिक्कत नहीं आएगी हार्दिक, okay? That is not an issue. जहाँ नहीं समझ में आएगा, मैं है ना, जब मैं बैच पढ़ाता हूँ तो हिंदी इंग्लिश दोनों में बात करता हूँ मैं, ठीक है ना? English, then I also talk in Hindi as well. if you are not a law student, then I will suggest that you have to please join any course, right, and then you study, right, because if you are not a law student, taking law optional by yourself is a very tough exercise. Okay, sir, can I get the format how to write it? No, I have just dictated you the question. You simply take that particular question. You simply take that particular piece of paper, write that down. That's it. Nothing else is required. Okay. Good. So that will be all for today. Thank you very much.